I am 𝓥𝓲𝓫𝓱𝓪 and welcome to 𝓥𝓲𝓫𝓱𝓪𝓷. In this video, I'll explain Class 11th Political Science Chapter 6, which is Judiciary. Now we all know the importance of judiciary in protecting our fundamental rights, which we have already studied in previous chapters. In this chapter, we will see different aspects of judiciary. Now there are many people who think that judges or the courts are only the arbitrators of individuals and private property, but judiciary has political functions as well, and that is what we will study in this chapter. In this chapter, we will study the independence of judiciary, the role of judiciary in protecting our rights, the jurisdiction of the judiciary, and the relation between the judiciary and the parliament. Now we all know judiciary is a system of integrated judges and courts in our country and is also one of the most important organs of our country. We also know that you have to know that the Supreme Court of India is one of the most powerful courts in the world. So we will be studying these all topics in this chapter, and without any further ado, let's get started with the first topic, that is, why do we need an independent judiciary? So we have been saying independence of judiciary, and you may have read in the newspapers, magazines as well, that independence of judiciary is very much important for doing justice in a society. So why we need an independent judiciary becomes the first question. Now you know what, that in a society there are bound to arise many disputes, some kind of disputes between individuals or groups, or between the groups and individuals and government. So to settle those disputes, we need an organization, and that organization is judiciary. Now, except that it is not an organization, it is an organ of government. So to settle all kinds of disputes in our country, judiciary is responsible, and it follows the principle of rule of law. Now this idea of rule of law implies that all citizens, no matter where they come from, what background they are, backward or forward caste, rich or poor, men or women, are applied to the same law. Same law is applicable to all of those people. They are equal before the law. And to establish the supremacy of the law and this idea of rule of law, judiciary is responsible in our country. Now if it has to do these many big functions, then it is very important that it is independent of any political pressure, and that is why we need an independent judiciary. Now as we have seen the need for an independent judiciary, let's get to the meaning of independence of judiciary as well. So independence of judiciary. Now independence of judiciary means that other organs of government like the executive and legislature must not refrain the structure or the functioning of the judiciary in such a way that it is unable to do justice. Secondly, the other organs of the government must not change the decisions made by the judiciary. Third, the judiciary must be able to perform their functions without any fear or favor from any other organization. Now these are some criteria or the meanings of the independence of judiciary. It's not like that judiciary is not accountable to anybody. They are accountable to the people of India, to the citizens of India, and the democratic citizens, democratic traditions of our country. As we all know, the supreme law of our country is the Constitution. So the judiciary is accountable to the Constitution as well. Now, the Constitution of India has prescribed many provisions for the security for the independence of the judiciary. First of all, the appointment of judges is not made by the legislatures. That would lead to party politics. So, to become a judge, a person need not have any political loyalty. To become a judge, to be appointed as a judge, a person must be well versed in law and should have an experience in this lawyer advocacy. So to be appointed as a judge, a person must be an experienced practitioner and or must be well versed in law. That is required to become a judge of High Court, District Court or Supreme Court. Now, legislature is not the one involved in the appointment of judges, but the executive is. Secondly, the judiciary is provided the security of tenure, except in some cases. Now, security of tenure ensures that the whole term of office is followed by the judge, and in some except rare cases they may be removed in grounds of some things. So that means that with the security of tenure, a judge would be able to do his or her work in very functioning way, in very efficient and effective way. Thirdly, for the financial resources like the salaries and the allowances, the judges are not at all dependent on the legislatures. We all know that financial resources are controlled by the legislatures, the parliament, but for the salaries and allowances, they are not dependent on the legislatures. They have been provided financial security as well as to maintain the independence of judiciary. So there are many provisions in the Constitution of India which lead to the independence of judiciary. Now, third, we shall come to the appointment of judges. So, appointment of judges. Now, as I already said that for the appointment of judges, legislature is not involved. Who are involved are the executive. Now, from governor to chief minister, from president to council of ministers and the chief justice of India, they all are involved in the appointment of judges. Coming to that point, first we shall discuss the chief justice of India, how they are appointed. Now, we all know that chief justice of India is the highest judge of our country, and over the years a convention has been made that the senior most judge of the Supreme Court becomes the CJI of the country, although it has been broken twice in the history of India. For example, in 1973, Justice M.H. Big became the CJI of our country, superseding Justice Khanna. So we can say that there have been two cases in which a judge has been appointed as a CJI who was not the senior most judge of our country, of the Supreme Court. So over the years, convention had been made that this senior most judge of the Supreme Court would become the CJI of our country. And after that, President, with the consultation of CJI, appointed the judges of the Supreme Court and High Court. Now, you should know that for the appointment of judges, the philosophy of constitution becomes very important at High Court level as well as Supreme Court level. Now, what happened earlier was that if the president was making appointments for the judges, then it means that the final power for the appointment of judges rested with the council of ministers, because president is bound to act with the advice of council of ministers, and that's why the role of CJI got to be questioned in the Supreme Court. Now, in Supreme Court in 1982 and in 1998, these type of cases where the question about the power of CJI came up, and that is why the Supreme Court introduced a system of collegium. The principle of collegiality means that the CJI of our country, with four more senior judges of the Supreme Court, with advice of theirs, will appoint the judges of the Supreme Court and High Court, and they will discuss that with the President as well. So the CJI, with the four senior most judges of the Supreme Court and the President of our country, appoints the judges of the Supreme Court and the High Courts. That is the procedure of collegium in our country. The principle of collegiality has been questioned as well before the Supreme Court, but till now it has been followed in our country. So you should understand that for the appointment of judge as a Supreme Court and in High Court, a person must have experience and being well versed in law as well. Now, next topic that comes here is removal of judges. Now, a judge can be removed only on the grounds of incapacity and misbehaviors. That means that they have used arbitrary powers, like they have misused their powers, they have used their position as a judge in Supreme Court or High Court or District Court to do misbehaviors to the less powerful people. So, a judge can be removed only on the grounds of misbehaviors and incapacity. And to do that as well, we need a motion in Parliament with a special majority. Special majority, as we have already discussed that in the chapter of elections, that means all the member of Parliament, like more than half of the total strength of Parliament must give vote in favor to remove that judge. So that means that not the general majority of 2/3 of the members of Parliament, but the special majority is needed to remove a judge. Now, there is one thing to be noticed, that executive plays a very important role in the appointment of judges, and for the removal of judges, legislature plays an important role, because the motion for the removal of a judge is being carried out in the legislature, which should have a special majority. Now, there is a case of 𝓒𝓲𝓫𝓱𝓪. 𝓒𝓲𝓫𝓱𝓪, against him the first ever motion against a judge of for the removal of judge came up. Now, he was the Chief Justice of Punjab and Haryana Court in 1991, who was found guilty of willful and gross uses of public office and public funds in his private uses. He was found guilty of moral turpitude by using his office as well. Now, against him, a motion started in the Parliament in 1992, which even got approval by 108 members. That was majority of that Parliament members. But he survived that motion because it was not the special majority, that is 1/2 of the total strength of the Parliament, and that's how he survived that motion. So we can say that first ever case for the removal of judge came for 𝓒𝓲𝓫𝓱𝓪 in 1991, for which the motion was carried out in 1992, and he survived that motion. So the removal of a judge becomes very hard only on the grounds of proven misbehaviors and incapacity. Now, the next topic that comes here is structure of the judiciary. Now, we all know that in India we have an integrated system of judiciary. That means that they are all connected rather than having different courts in different states, that is in any other federal country, because we are not a complete federal country, we are a quasi-federal country, and that's why we have an integrated system of judiciary. Now, in India, we have a pyramidal system of judiciary, on top of which is the Supreme Court of India. Now, Supreme Court is the highest court of India, which can transfer any case to itself from any of the other courts. It can transfer the judges of high courts from one high court to the other high courts. Then it can make different kind of jurisdictions as well. It is binding on all the other courts of our country. After which comes the high courts. Now, there are different high courts in different states of our country. They are above the lower courts, above the district courts. They can hear appeal from the district courts. They can also issue writ jurisdiction, and after that they are binding on the district court and the lower courts. After high courts come the district courts. Now, district court is on the district level. In each district there is a district court which hears appeals and cases from the lower courts. Now, lower and subordinate courts are those kind of courts which hear civil and criminal matter of nature. So these are the structure of the judiciary. Like, the highest court is Supreme Court, then after comes the High Court, then after comes the district courts, and then after subordinate courts. Now, let us see their functions as well with the next topic, which is jurisdiction of Supreme Court. Jurisdiction of the Supreme Court becomes very important because it is bound by the constitution of our country. There are many special provisions, special powers held by the Supreme Court of our country, but which is in limitations with the constitution of our country. That is very important. It's not like we have given all the power to the Supreme Court of India. Now, some jurisdictions of the Supreme Court are original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction. Now let's discuss all of them one by one. First being original jurisdiction. Original jurisdiction implies that Supreme Court acts as an umpire in disputes of federal nature, disputes between the union and the state governments, and among the state governments is solved by the Supreme Court of our country. It is called original because only the Supreme Court has the jurisdiction to solve this kind of disputes. Neither the high courts nor the district courts or lower courts can solve this kind of matters. So only the Supreme Court has a jurisdiction to solve the matters of the federal nature. For suppose like there is a dispute of land, there is a dispute of water resource between the state of Kerala or Goa. Now what happens that if that dispute has to be solved by the Supreme Court of our country, if there is a dispute between 2 states, 3 states, among the states, or between the union and the state governments, it is called the original jurisdiction of the Supreme Court. Next comes writ jurisdiction. Now, writ jurisdiction, as we all know that they are held by the Supreme Court and High Courts as well to protect the fundamental rights. Now, under Article 32, it is given to the Supreme Court of our country, and under Article 226, it is given to the High Courts of our country as well. We do know that there are some writs given to the Supreme Court, such as certiorari, such as mandamus, habeas corpus, prohibition, quo warranto. So these are the writs that is provided to the Supreme Court and the High Courts of our country to protect the fundamental rights, and the Supreme Court and the High Courts of our country can issue these writs to protect our fundamental rights. Now next jurisdiction is appellate jurisdiction. Now the Supreme Court is the highest court of appeal. We all know that, and that is why it has the appellate jurisdiction as well. Appellate jurisdiction means that any person can go appeal in the Supreme Court against the decisions made by the High Courts. Of course, High Court will decide whether they will certify whether that case is of public importance, whether that case is of super importance for the interpretation of the Constitution or of any law. Now, Supreme Court can hear that appeal or not. It depends on the Supreme Court. It can go against the decision made by the High Courts if it thinks that the interpretation of the law or an article of the Constitution is done wrongly by the lower courts, by the High Courts of our country. And that's why, if a person is not satisfied with the decision made by the High Courts of our country, now they would go to the Supreme Court for appealing. The High Court would issue a document regarding the matter, whether it is of importance or not. It depends on the Supreme Court whether they accept that document or not. They can hear that appeal or not based on the importance of the matter. Now, High Courts also has this appellate jurisdiction. High courts have this kind of appellate jurisdiction against the lower courts and the district courts. Now, if there is a decision made by the district court and which a person wants to go against, then they can go to appeal in the High Courts as well. So the Supreme Court and the High Courts of our country both have this appellate jurisdiction. Next comes advisory jurisdiction. So advisory jurisdiction Now, the President of India can refer any matter which is of public importance or which involves the interpretation of the Constitution to the Supreme Court for advice. So, the Supreme Court, apart from possessing original jurisdiction, writ jurisdiction, and appellate jurisdiction, also possesses this advisory jurisdiction in which it can give advice to the President of India, which is on matters which are of public importance or which involve the interpretation of the Constitution. Now, you should notice that the Supreme Court is not bound to give advice on such matters, and the President is not bound to follow that advice. So it is kind of both parties are free whether to give advice or whether to follow that advice. Now, then what is the utility of this advisory jurisdiction? It has twofold impacts of our administration. First is that President can seek legal advice on a matter, so it can make actions based on legal advice given by the Supreme Court of our country, which can later on prevent unnecessary litigations. Secondly, it can change the course of its action based on that legal advice. So it has two impacts based on those advices. So Supreme Court alone possesses this advisory jurisdiction. Now, there are two articles that need to be noted. First is Article 137. Now, Article 137 says that subject to the provisions of any law made by the Parliament or rules under Article 145, the Supreme Court shall have the power to review judgment pronounced or order made by it. Then after Article 144, all authorities, civil and judicial, must function in the aid of the Supreme Court. Now here they tell the powers of the Supreme Court. We see that Supreme Court is binding court on all the territory of India. Its order is a supreme in all the territories of India. That is why all the authorities, whether they are civil or judicial, have to act in aid with the Supreme Court. Secondly, even the Supreme Court is not bound by itself. Now, suppose there was judgment made by the Supreme Court. Now, later on, after a decade or maybe two, they can change that judgment provision or that order by themselves. So the Supreme Court is not by itself as well. So these two articles state the importance of the Supreme Court of India in our country, and that is the advisory jurisdiction of the Supreme Courts of India. Now, the next topic that is here is judicial activism. Now, judicial activism refers to the activities of the judges or the courts promoting the civil rights of the citizens, promoting and upholding them as well. Over the years, judicial activism has revolutionized the functioning of the courts in our country. Now, you may have heard a term public interest litigation or PIL, which is also known as social action litigation or SAL. Now, what is PIL or SAL? Now, earlier, over the course of law, what used to happen that a person could appeal in a court when he or she was personally aggrieved. That is to say, if the person's right is violated, or that person is involved in a dispute, then only that person could go to the judges, could go to the courts of our country. That way of thinking, that way of litigation changed in the year 1979 when the Supreme Court heard a case where the petition was not filed by the aggrieved persons but some other person. So now, this was for the public interest, and that is why these kind of litigations came to be known as the public interest litigations. Public interest litigations means that not the person who's aggrieved himself can go to the courts, but public spirited citizens or the volunteer organization can also go to the Supreme Court or the High Courts for the appeal if they see that justice is not being done in our country. Now let us see some of the earliest PILs which were very important or pioneers in the history of PILs. Now first ever PIL in our country was in 1979, which was 𝓥𝓲𝓫𝓱𝓪 versus Bihar case. Now what happened, there were some under trials in prisons who were imprisoned for a long time, longer than what they would have been if they had been tried in the court for their offenses. So they had been in prison for a very long period of time. If they had been tried in the courts for their offenses, they would have a shorter period of time that they would have to spend in the prisons. So that's why, of course, it was against the humanity or morality, and that's why the petition was filed in the Supreme Court of our country, and it decided to hear this case and gave its judgment. Second very important PIL case was 𝓥𝓲𝓫𝓱𝓪 versus the Delhi administration. Now what happened that there were some prisoners who, there was a prisoner in Tihar jail of Delhi who gave a scribbled letter to Justice Iyer of Supreme Court. Now on that paper was written the physical torture given to the prisoners. Now you know what, that even the prisoners have their rights, as we have already seen in the fundamental right chapter, that they have their own rights as well, and that's why they can't be tortured by the will of the officers. So the court decided to hear that case. An advocate filed that case, filed petition for that case, and the court decided to hear that case. Although it decided that later it would not consider a letter for a petition. So we can see that these two are very important pioneers in the history of PILs in our country. Now public interest litigations. What happened earlier that the judges or the courts of our country had to give judgment on those cases that had been brought before it, but now they could solve those cases as well that had been given to the courts in the form of newspaper complaints or the postal complaints. Now they were considering those cases as well. So this PIL revolutionized the functioning of the courts in our country, after which there were many public spirited citizens, there were many volunteer organizations that demanded for betterment of living condition of the poor, protection of the existing right, unpolluted water, good quality of air. Now they were demanding such rights of the people. Whenever they were violated, they could directly go to court to file a petition on behalf of the aggrieved person, which gave access to the all sections of the society of our country. So the PIL enabled different sections of the society to have an access to the courts of our country, and courts also willingly gave judgments on those matters. So there are many good benefits of the PIL. However, there have been negative impacts as well. What are those? First of all, so many litigations have overburdened the courts of our country. There are still many pending cases in our country which have been pending for long years, for a very long period of time in the courts of our country. Secondly, the PIL has literally erased the line between the executive and legislature on one hand and judiciary on the other hand. Now you know what, that generally or normally these cases for betterment of living conditions of the poor, good quality of environment should be solved by the administration under the supervision of legislature, but now the judiciary was doing so. So it has been said that the original function of the judiciary had never been to solve these kind of things, to provide these kind of rights. Its work is to give justice on any matter, and that's why the functions of the judiciary, like the line between the legislature and executive on one hand and judiciary on the other hand, has been erased by this PIL, which is very troublesome, because these works have to be done by the government of our country rather than the judiciary of our country. So although the PIL, judicial activism, has improved a lot of functions in our country, like there have been many cases that have been filed in the courts of our country and which have been heard as well. People have been provided justice as well, but still there are negative impacts as well. Moving on to the next topic, judiciary and rights. So as we all know that the Supreme Court has been bestowed to provide remedy for the violation of the rights. They are seen as the protector of the citizens' fundamental rights, and that's why they should have power to do so as well. Now there are two ways by which the Supreme Court remedy the violation of rights. First is, of course, to issue writs, which is Supreme Court as well as the high courts of our country can do. High courts can also issue writs on such matters. Second is, the Supreme Court can declare any law unconstitutional and therefore non-operational if it sees it as in violation of right under Article 13. So that means there are two ways by which the Supreme Court of our country can provide remedy for the violation of rights. Now, perhaps the most powerful decision that judiciary can make is of the judicial review. Now, Supreme Court has the power of judicial review. Judicial review means that it gives the Supreme Court and High Courts to examine the unconstitutionality, like to examine the constitutionality of a law, and if the Supreme Court, if the court has found that law as being inconsistent or being unconstitutional with the Constitution, then it can make that law as unconstitutional and thus inapplicable. So judicial review literally means that if a law has been made by the Parliament which is inconsistent with the Constitution of our country, then the Supreme Court, with the power of judicial review, can review that law, the constitutionality of that law, and then can declare that law as unconstitutional and thus inapplicable. It relates to the federal matters as well. Now, what do you mean by federal matters? That means you do know that there are state list and union list. Now, suppose union government has made laws which reportedly by state governments is of state list. So the Supreme Court, by the power, by the virtue of the judicial review, can declare that law as unconstitutional. So Supreme Court has this power of judicial review on laws made by the legislature as well as on federal matters. So if a state is making laws which is not of the state list but of the union list, then that law will also be considered as unconstitutional. Perhaps this is the best or the most important power of the Supreme Court. Now you do know that we have the PIO system in our country which gives access to the all sections of the society. Now suppose people have been exploited, they have been trading organs, they have been, we have seen in fundamental rights chapter, right against exploitation, which prohibits the trafficking, the human trafficking, trade in meats of the human, flesh of humans. Now how can those persons who have been exploited reach the court? Because they have already been victim and they are trapped in that place. So for that we have the PIL system in our country. So together with judicial review and PIL system, Supreme Court has become very powerful in our country, and that's why we see that rights have been protected by the Supreme Courts, and which is very important as well to make the country democratic and have an independent judiciary as well. So this is the relation that we have between the rights and the judiciary. We see judiciary has the power to enforce any law, to consider any law as unconstitutional, and it is binding, it is enforceable to all the territories of our country. Now the next topic here is judiciary and parliament. Now, as we have already seen the relation between the judiciary and the rights, we have also seen over the course of history that judiciary has had active stand on parliament as well. You know what, that it has been having active stand on the protection of rights as well as to prevent the subversion of the constitution in the party politics, and that's why many times the judiciary has initiated effectively to direct the decisions made by the administration, made by the legislature. Now, the Constitution of India provides very clear separation of powers. Like the legislature is responsible for making and amending the laws, the executive is responsible for implementing those laws, and judiciary is responsible to settle the disputes as well as to maintain, to see whether the law is consistent or not with the constitution. Even after having these kind of check and balances, the system of checks and balances and clear separation of power, we still see many disputes between the legislature and judiciary and executive and judiciary. Now, over the years, what has happened, whenever judiciary sees that the legislature or the executive is not working with being consistent to the constitution, they have initiatively got into that matter. For example, it has initiated the agencies, executive agencies such as CBI. It has given directions to such agencies like CBI to go against politicians and bureaucrats, to investigate against those politicians and bureaucrats in some of the very important cases, such as the 𝓒𝓱𝓪𝓾𝓱𝓪 case, the improper illegal allotment of petrol pumps case. So there have been many cases in which the judiciary of our country has directed some very prominent executive agencies to go against politicians and bureaucrats to maintain democracy in our country, and that is why there have been many controversies between the legislature and judiciary and executive. Now we will see an example of that as well, that is for the right to property. We all know that the right to property is no longer there, but still how it was removed is also a big thing. You know what, that the parliament wanted to repeal this article, which was a fundamental right, so that it could easily enact the land reforms. Now it wanted the private land for public uses, and that's why the parliament, in name of enacting the land reforms, easily wanted to repeal this fundamental right, which was the right to property. Now the Supreme Court at that time was against this decision. It said that even with an amendment, the parliament cannot erase the fundamental right of the citizens, and that's why between 1967 and 1973 there have been many controversies, not just this case, between the legislature and judiciary. These were for the land reforms, using private property for public uses, reservation in jobs. There have been many things on which the controversies were going around between 1967 and 1973. And finally, in 1973, one of the most famous cases, judgments, was given by the Supreme Court of our country, and that was 𝓥𝓲𝓪𝓾𝓱𝓪𝓷 case. Now in 𝓥𝓲𝓪𝓾𝓱𝓪𝓾 case of 1973, Supreme Court introduced the basic structure of the Constitution. Now it said that there would be a basic structure of the Constitution which the Parliament cannot repeal, cannot erase even with an amendment. Now it did two more things. First was that the right to property, on which the controversy started was not included in the basic structure of the Constitution. Secondly, the Supreme Court of India gave itself the power to decide whether a law is the basic structure of the Constitution or not. So the basic structure of the Constitution is decided by the Supreme Court of India, which includes independence of judiciary and some of the very prominent fundamental rights as well. So it has been one of the most important judgments declared by the Supreme Court of India, and that's why it becomes very important to understand it as well. So we can say that between the Parliament, between the administration and judiciary have been many controversies. Like even today there have been many controversies. For example, legislature has been given power to maintain itself and to breach any person if that person has been found guilty of misusing his or her power. The legislature will be responsible for that person's punishment. Now there have been many questions arising whether that person from legislature can go to the court seeking protection and whether the court can provide protection to that person. Now these questions remain still even today, and they have been matter of controversy between the judiciary and legislature, in between the judiciary and executive, because the main function of the judiciary is to provide justice in our country, and it provides that how it interprets the Constitution of our country as well. Now, as we see that in 1973 𝓥𝓲𝓫𝓱𝓪 case, the Supreme Court used its power of interpreting the Constitution. It has the power to interpret the Constitution and give advices on that. So it used its power at its maximum level as well, and we see that how judiciary can be powerful in our country. So this is how we can say that Parliament and judiciary have been very much controversial. Now there is one more thing, that under PIL system what happens there, judiciary also provides free and fair elections in our country. Now under PIL system what happened that all the contestants who want to stand in elections as being a contestant have to give affidavits of all their assets and income and their educational qualification, so that the citizens of India would elect all the members based on accurate knowledge. So with PIL system, judicial activism system, what has happened, judiciary has become more active and powerful. Even when it directs executive agencies to go against politicians and bureaucrats, it is also a matter of judicial activism. So judicial activism together with judicial review, PIL system and different jurisdictions of the Supreme Court has made the judiciary of our country very much powerful. Now the last but not the least is conclusion. Now, what have we concluded in this chapter? We have seen overall in this chapter that judiciary is very powerful institution in our country, whose main function is to provide justice to all the people, to all the citizens of our country, without seeing their race, their religion, their caste, their economic background, their everything, irrelative of everything. They have to provide justice to all the people, for which it has been doing. We have seen the appointment of judges, which is the work of executive, and the removal of judges, which is the work of legislature. Now there is one more thing, that the current it is a fact that the current CJI of our country is Justice 𝓒𝓱𝓪𝓷, which is a very important fact that you should know. So in this chapter there are very important things like the removal of judges, how they can be removed, and the approval of the appointment of the judges. Then the jurisdiction of the Supreme Court and High Courts, how they can issue their power, how they can become more and more powerful, and one of the most important things, that is judicial activism. So over the years we have seen judiciary is becoming more and more powerful and thus doing its work. Still there are negative impacts, that is the courts in India have been overburdened. There are still many cases in Indian Indian courts which have been pending for long periods of time, like over 20 years, 30 years, even more than that. So that is a matter of concern which needs to be discussed, which needs to be changed. So that is all we have discussed in this chapter. I have covered all the topics and subtopics. In the next chapters of this book will be covered in the further upcoming videos. So stay tuned for the upcoming videos. Thank you very much.